I mean, there is a foundational confusion that sits at the heart of the Indian contempt jurisprudence, that it must be named before anything else can be said clearly. The assumption that judicial authority is harmed by the criticism rather than rather than earned through it. So this assumption is not merely wrong. I mean, it is paradoxically self-defeating, because every time a court uses its contempt powers to silence a critic, it confirms in the public mind exactly what the critics suspected, that the institution cannot withstand any scrutiny. Lord Atkin, I guess, said in Ambed versus Attorney General versus Trinidad and Tobacco in 1936, and he wrote words that remain perhaps the finest judicial formulation on the subject, that uh, justice is not uh, cloistered virtue. She must be allowed to suffer the scrutiny and respectful. Even though outspoken comments of ordinary man, it should come out, and it should be sustaining those reforms and those situations. Because if you see, this was not a radical statement by Lord Atkin, it was an acknowledgement of something very ancient, that legitimacy for any institution in a democracy flows upward from public trust and not downward from institutional power. When you try to curtail the power from the public criticism, you technically trying to say that you will lose respect from your own citizens, from your own country, just because somewhere in the book which is written on some genuine facts and genuine ordinary extraordinary understanding of how the system is working, and it tries to pick out the lacunas that is there in the system. And the presumption comes that if these ideas are spread in the public, that will eventually lose the respect of the judiciary, is comes technically comes from the presumption that we do not know how our citizens are, and we do not know how our people will be. There are a lot of reforms, there are a lot of criticism about many institutions, but do people lose credibility of those institutions so easily? I feel and I believe that it is not that easily to be done. It is not about it is not about, until unless it is about the court, it is until unless it is about the judges, until unless it is about the understanding, interpretation, something which is very fundamental to the institution, that is the system procedural understanding of that whole subject. And there is genuine system lacuna that is been there in this whole procedure. If we try to avoid that, if we try to curtail it down, it shows that we are technically doing something which, like I said, the critics were expecting us. As SP Sathe observed in his explanation, that what he called the paradox of legitimacy of the judiciary, that the courts have to sustain their social legitimacy through their decisions and through people's belief that they are objective, impartial, or they are principled. So their decisions might be wrong according to some people, but some decisions may be severely criticized. So the legitimacy of the court increases by allowing such criticism. Any criticism, any dissent forms the very basis of a free society. And this is the central insight that India's contempt and contempt apparatus consistently fail to internalize this thought, that an institution that suppresses the criticism does not become more credible, and it becomes rather it becomes more suspect to these criticism. The very act of suppression is itself a confession of fragility. you know the colonial inheritance never try to shed off is that to understand where Indian stands, one must understand where the law came from. So the concept of contempt of court has its origination from England, where the law was linked to the kingship and the sovereignty. So judges administering the justice derived their authority from the king and sat in the courts to administer justice in the king's name. So thus any disgrace or disregard of the rule of law, or offense against the dignity of a court or a judge, was considered an insult to the king himself. Now, if you if I'm allowed to say that again, that the entire architecture of scandalizing the court was built on the premise that the judge spoke for the sovereign, and criticism of the judge was in effect to the to the kingship itself, and it was designed for monarchies. It was imported wholesale into a constitutional republic, that these are the things that build the respect of the people. And in any formulation, the first contempt of Courts Act in India was introduced in the year 1926, the Parliament drafted the Contempt of Court Act, and it entered the Gazette in the year 1971. So, in the year 2006, Section 13 was amended, and it is now a settled position of law that truth is a valid defense for the contempt. The 2006 amendment, which allowed the truth as a defense, was a small step forward to understand why criticism is even much more important to the institution that is administering the justice. But it did not technically resolve the deeper structural problem that was there, that the colonial era law does not require proof that the statement has led to actual interference with the administration of justice, or rather the undermining the public confidence in deciding whether these was contempt or not. And I mean, think about what that means. You do not have actually lowered the public confidence. You do not have to actually interfere with any proceedings. The mere tendency, as assessed by the very judges who are very subject to these criticism, is enough. I mean, you do not require anything else. The court is prosecutor, victim, judge, and jury simultaneously. I mean, Justice Krishna Iyer, in a 1974 judgment, categorically wrote that a vague and wandering jurisdiction with uncertain frontiers, a sensitive and a suspect power to punish the vested in the prosecutor, a law which makes it a crime to publish regardless of truth and public goods and merits, a process of brevi manu conviction may unwittingly trust upon the civil liberties. So, brevi manu, by a shorthand, summary conviction, no injury, no independent prosecutor, the court moves directly from the accusation to punishment, often with itself as the aggrieved party. Now, Justice Krishna Iyer said called it a very vague and a wandering jurisdiction 50 years ago. Now, it remains exactly that today itself. The anatomy of separation that disturbs us. So, if you see this terrain carefully, because the cases reveal pattern for itself that is more troubling than any individual instance. The case of if I'm spelling it right, it is Namboodiripad case, which is E.M.S. Namboodiripad. The Chief Minister of Kerala in 1970 made a speech arguing that the courts function in the intersects of property owning classes and were structurally biased in the favor of capital. And this was a purely Marxist critique that was not against any particular judge, not of any particular verdict, but of a class character that the institution itself was carrying. So the Supreme Court held that while the freedom of speech is a constitutional right, it is not absolute. And the court also emphasized that the statements that scandalize or bring disrepute to the judiciary constitute the contempt of court. Now, Namboodiripad was convicted of criminal contempt and fined, and he affirmed the judiciary's role in preserving its dignity and authority. Now, the specific critique that courts in a capitalist system trying to protect the property is not a fringe position. It is an academic argument made by the legal scholars, political philosophers, many jurists across the world. Marx, Gramsci, Pashukians, and in a different register, the American legal realist, all engage with these questions. A sitting chief minister was convicted for expressing in a political language what law professors routinely write in peer-reviewed journals. And this is the problem with whole the system. The implication was very clear. The systemic criticism of the judiciary, criticism that questions its structural foundations rather than merely a particular decision, is not fair criticism. It is contempt. If you see the Prashant Bhushan case, which is famous Prashant Bhushan case, a senior advocate with decades of practice before the Supreme Court posted two tweets. One asked whether the Supreme Court had played a role in the destruction of democracy over the last 6 years, and second criticized the Chief Justice of India for reportedly using a motorcycle during the COVID lockdown while the Supreme Court remained close to ordinary litigants. Now, the Supreme Court took the suo motu cognizance of this tweet, holding that the tweets brought the administration of justice into disrepute and were capable of undermining the dignity and authority of the institution of Supreme Court in general, and the office of the Chief Justice of India in particular in the eyes of public at large. The apex court demanded an unconditional apology from Mr. Prashant Bhushan, which he refused, of course. Bhushan's refusal was, technically principled and carefully worded. He said, in effect, that he could not, in good conscience, apologize for statements he believed to be true, because doing so would itself be a technical lie. More than 3,000 former judges, retired bureaucrats, journalists, and lawyers signed a statement called the judgment a disproportionate response that would have a chilling effect on people who were expressing the critical views on the judiciary over those times. Over 1,800 lawyers signed a statement challenging the ruling. So, you see, the Supreme Court ultimately imposed a fine of rupees 1, a symbolic amount which they called. But that is the problem. A symbolic fine does not, uncreate a criminal conviction. Prashant Bhushan is, as a matter of record, a convicted criminal contemptor for having tweeted criticism of an institution. This is just a dichotomy of where we are living in. The fine being nominal does not make the conviction less real or less chilling or less instructive about what the court believes it is entitled to protect itself from. So the court generally was becoming pricklier when it comes to issues of free speech, as evidenced in the Prashant Bhushan case. So in a display of self-proclaimed magnanimity, the court let off Bhushan with a rupee 1 fine, but not without chastising his conduct. In the entire proceedings, one thing was very clear: the court came across as an intolerant institution, or rather, I would say, intolerant institution. The Konal Kamra and Rachita Taneja case of 2021. The Supreme Court decided to proceed with the criminal contempt of the court cases against the Shandam community Kunal Kamra and Rachita Taneja, and issued notice to both of them. The contempt proceedings against Kamra and Taneja are based on tweets and about the Apex Court and its judges, including the Supreme Court. Supreme Court granted the interim bill to journalist or Arnab Goswami. So a case that was involving Rachita Taneja is, emblematic of the evolving challenges that the judiciary faces in the digital and creative realms, where the lines between the artistic expression and the contemptuous conduct are increasingly blurred. The Attorney General argued that the cartoons were not merely expression of artistic freedom but deliberate attempts to degrade the authority of the Supreme Court. Note that the argument is not that the cartoons were false. The argument is that they degraded the authority. And this is the monarchical logic reappearing in democratic grab, that the problem is not the untruth, it is the disrespect. And that is where the real problem lies. The problem that led me to make this video is the NCRT textbook ban. This is perhaps the most extraordinary recent instance, because it is not about a tweet or a cartoon or a lawyer statement. It is about the school textbook. The Supreme Court came down heavily on the NCRT publication of a class 8 social science textbook. There were few chapters with references to the corruption in judiciary. Any of the judges, if they are sitting in the court, they can say with the open heart that it is not. Issuing a show cause notice to the Secretary of the School Education and the NCRT director as to why action under the contempt of court should not be taken against them. So, chapter technically included a section on corruption in the judiciary, along with the discussions on a massive backlog of cases. The chapter also quoted former Chief Justice of India B.R. Gawai, who said that the instances of corruption and misconduct within the judiciary had, adversely affected the public confidence. The bench described the content as a deep-rooted conspiracy to defame and demean the dignity of the judicial institution. Let that sink in. The chapter quoted a former Chief Justice of India, highest judicial office in the land, making the same observation about the judicial corruption, and the court described including that observation in a civic textbook for a 13-year-old as a deep-rooted conspiracy. By that time the NCRT textbook lands on the desk, they likely already know about the Justice Yashwant Verma episode and the discovery of large amounts of unaccounted cash at a sitting High Court judge residence, the subsequent inquiry, and the protracted and still unresolved process of accountability. So they know about the 4.7 crore pending cases in the districts. They may have heard adults complain about having to manage lower court proceedings. Against the background, the textbook arrives as a formal endorsement that these issues are part of country's civic conversation. So the child looks at the textbook, which tells them that the corruption, pendency, and inadequate judicial infrastructure are challenges facing the Indian judicial system, and then looks up to see the Supreme Court calling this a calculated conspiracy to defame. This is the contradiction made very visible to whole public who are watching it from the outside. The court is telling a child what you know, what your parents know, what the former chief justice said. That is contempt. Only you have to keep silence, which is only acceptable. So why the judiciary is not entirely wrong? I mean, there is some arguments with respect to the analysis, that analysis should be honest, and I'm not on the either side, because the case for a judicial protection from criticism is not frivolous. It is incomplete but not frivolous. First thing first, the judiciary has no political constituency. Unlike politicians who can campaign against their critics, or executives who can use the bully pulpit, judges cannot respond. They are bound by the convention and ethical rules not to enter the public debate about their own decisions. So, a sustained and a bad faith campaign of misinformation against a court, if left unanswered and unaddressed, could genuinely erode the institutional legitimacy that makes judicial orders, enforceable at all. And this is something to be, and there is something to this concern. I mean, technically. Secondly, to have an argument is that the India is not Scandinavian country. The argument that matures democracy tolerate criticism must grapple with the context, and in societies with strong civic literacy, where people routinely distinguish between the systemic criticism and the personal attack, the risk of uncontrolled judicial criticism may be manageable. But in a society where political leaders routinely weaponize the institution, where a criminal charge against a judge can be manufactured to destroy the judge's family or derail a case, the calculus is much more complicated than we understand or assume. Thirdly, I would say that not all criticism is made in good faith, because some contempt cases involve not whistleblowing, not civic commentary, but rather it is coordinated smear campaign against judges who are deciding cases in politically inconvenient ways. And the contempt power in those cases serves a genuine protective function. So, shielding the administration of justice from being strangled by those who direct, at the stake in the outcome. If you see the case of DC Saxena versus Union of India, where Justice Ravi Chandran or Ravindran quoted the Chief Justice John Marshall, who had warned 2 centuries ago that the power of judiciary lies not in deciding cases, nor in imposing sentences, nor in punishing for contempt, but in the trust, confidence, and faith of the common man. And this is Marshall's insight pointing two directions at once. Yes, the power lies in public trust, and therefore contempt powers exist to protect that trust. But also, the more fundamentally, it is the public trust that gives the court its power, not the contempt apparatus. So if the trust evaporates because the court is seen as corrupt or incompetent, no contempt order will restore it. So the medicine and the disease are technically correlated to each other. The comparative picture, what we can look at from the United Kingdom, that is that the Crime and the Court Acts, which is 2013, they technically abolished the offence of scandalizing the judiciary under the common law of England and Wales. That means the scandalizing the judiciary, also referred to as scandalizing the court or scandalizing the judges, is abolished as a form of contempt under the common law of England and Wales. So Section 33 was there. So this is not a small development. England is the country that invented this law, and it exported to it every territory it colonized. And then in 2013, it looked at the law and concluded that in a modern democracy, it was indefensible. So England abolished the offence, citing the law as an infringement of freedom of expression that should not be retained without the strong principle or a practical justification. The call to abolish the offence arose in 2012, when the Attorney General of Northern Ireland obtained leave to prosecute a sitting MP following the comments in his autobiography about a High Court judge. So although the proceedings were withdrawn, the proposed use of the offence caused the considerable disquiet in Parliament and more widely. They were perceived by many as a serious attack on free speech. The sequence was that the politician wrote in a memoir that a judge had behaved badly. The law allowed prosecution, but the Parliament was horrified. So the Law Commission examined the law. They concluded that it was obsolete and it was abolished. In England, when the law was used against a politician for a political commentary about the judges, the Parliament abolished the law. In India, when a lawyer tweeted political commentary about judicial conduct, the court convicted him. And these are different, conceptions of what democracy requires. The United States American position is you can see, the more robustly protective of speech than almost any other jurisdiction in the world. In the US, courts no longer use contempt to silence the common comments on judges or legal matters. The First Amendment to the US Constitution, forbids the imposition of contempt sanctions on the newspaper. So the underlying constitutional logic comes from the Bridge versus California case of 1941, where it says that the US Supreme Court held that free speech protections override the interest of courts in protecting their dignity from the public commentary. So the clear and present danger test is that the first articulated in the Shannock versus United States, which was applied to mean that only speech posing an immediate concrete danger to the ongoing proceedings could be restricted. Other than that, there is no requirement of such. Academic criticism, political commentary, satirical cartoons, none of these came close to that threshold. I believe that Canada's Ontario Court of Appeal in R versus Coipito held that the criticism must present a real and substantial danger to the administration of justice before being restricted. And real and substantial danger is not a tendency. It is not a possibility. It's not to hurt the feelings, but a demonstrated concrete danger to actual proceedings. This is proportionally in action. So proportionality in action. So if you see the comparative constitutional experience underscores the very concern. In the US, prior restraint is almost per se unconstitutional. The UK abolished the offense of scandalizing the court in 2013, which they recognized that the modern democracies must tolerate sharp criticism of judges. Canada requires real and substantial dangers. These jurisdiction technically reflects what a shared democratic instinct should be. So the UK Parliament realized that in a mature democracy, it is better that courts be immune to criticism, and judges are public servants, not the monarchs, and their authority should be in the exercise of the public respect, which eventually is public trust and judicial reasoning, and not in the threat of punishment against the dissent. So, at the core of scandalizing the court doctrine is an assumption that runs deep and is rarely articulated openly, that the ordinary people cannot be trusted to read the criticism of the judiciary and arrive at their own reasoned judgments. The exposure to criticism will automatically produce contempt, that the public mind is passively shaped entirely by whatever it is last encountered. So the basic idea is the same as seditious libel. If people are allowed to criticize state institutions in derogatory terms, then they can influence their fellow citizens, who in turn will lose respect for those institutions. So consequently, the authority of those institutions will be diminished, and they will be unable to effectively perform their functions. So hence we prevent that eventuality by prohibiting the certain forms of speech. I mean, this is of course is also entirely disrespectful of individual autonomy, but it is based on the assumption that the person legally and morally responsible for a criminal act is not an actor, but the person who is convinced that the actor through words and arguments, and as though individuals are incapable of weighing up the competing arguments and coming to a decision. This is the paternalism at its more explicit. The court is saying our citizens, when they read or tweet or cartoon, will be swept into contempt for us. They cannot be trusted to evaluate the criticism, weigh it against their own experience, and form a considered view. We must protect them from the information. But this assumption is not only disrespectful to these individuals only, but it is demonstrably false, because people who live in India know from daily experience in lower courts what the judicial system looks like on the ground, and they know about the pendency of the cases, they know about the cost of litigation. Many have personally experienced or observed what happens in subordinate courts. The 13-year-old who reads the NCRT books already has access to far more vivid and immediate evidence of judicial dysfunction than any textbook could provide. So the assumption that respect for the judiciary can be won by shielding the judges from the criticism, I mean, that misjudges the public opinion, because surely an enforced silence in the name of preserving the dignity of the judiciary would cause the resentment eventually, because the suspicion and the contempt, more than it would will increase suspicion and contempt more than it would enhance the respect. So I mean, enforced silence, I mean, in my view, does not produce respect. It produces exactly the suspicion it claims to forestall, because the court cannot stand on tolerate criticism, looks to a citizen's common sense like want something to hide. So I feel that there is a principle of natural justice so old that Latin formulation appears in medieval text Nemo Iudex in causa sua, which says that no one should be judged in their own cause. The contempt law is contrary to the first principle of natural justice, which says that no more shall be prosecutor and a judge at once. And the fact that these all things are the fact that it makes the deepest thing that can be said about the relationship between the judiciary and the public criticism is this, that an institution that is secure in its legitimacy does not need to punish who questions it. When the British Daily Mirror published photographs of three judges upside down with the caption "You fools" in 1987, the judges had the legal tools to pursue contempt. They did not. Lord Justice sadly reacted with a comment that not only deference but civility were not requirements of democratic expression. The Daily Mirror's front page was rude, it was not contempt. And we need to understand between what is called rude and what is not contempt. The British judiciary at that moment demonstrated a kind of institutional confidence that a court that convicts senior lawyers for tweets has not yet achieved. In a democracy, the people should have the right to criticize judges. The purpose of the contempt power should not be uphold the majesty and dignity of the court, but only to enable to it to function. Chief Justice, I mean Marshall, warning cited in the Supreme Court's own judgment, but really internalized, deserves the very last word. What Marshall said: the power of the judiciary lies not in the decrees, not in the punishments, not in the contempt orders, but in the trust, confidence, and faith of the common man. I mean, the court fears criticism is the court that fears the criticism is the court that should fear it. The court that cannot bear the criticized loudly, wrongly, and even unfairly is the court does not need to. So, that trust is built the same way the trust is always built. Slowly through conduct, through transparency, through the willingness to be held accountable. It cannot be demanded, it cannot be enforced, and it cannot be preserved by silencing those who suggest it has been lost. So, yeah, one of those rare occasions, as Sumanta Banerjee observed in a Veeraswamy case, that the manner in which the contempt proceedings are often initiated at the drop of a hat by some aggrieved members of the judiciary makes one wonder whether the tendency is not becoming comparable to the invocation of the blasphemy law by the religious establishment in Pakistan. This is sharp comparison, but it is not unfair one. I mean, the structure is parallel. A class of persons who hold special status use a law that only they control to immunize themselves from the criticism that all the other public figures must endure. That the only difference is that in India, the class in question is the administers justice, which makes the immunization simultaneously more consequential and more erosive. So, yeah.